Thank you so much, Lateef. I am Shelley Fullwood. I'm the supervising trademark attorney at NCC School of Law's Intellectual Property Clinic, and today we are going to talk about racism and branding. Our panelists, to start out with, we will start out with our Howard alum, LaNelle Owens, and she will tell us just a little bit about herself before we start.
Hello, everyone. Again, my name is LaNelle Owens, and I'm Assistant General Counsel, Head of IP at Thrasio, LLC, and I'm a proud Howard grad, class of 2004. And I remember as a student attending the first conference, IP and Social Justice, and I was in the first class of Todd Irving and Esther Lim. So I'm honored to come back and present and participate this year.
Thank you, LaNelle. Our next panelist is Makalika Naholowaa. She's the chief of staff for the General Counsel for Microsoft. Would you like to say a little bit more about yourself?
Of course, I was on mute. Hi, good afternoon, everyone. I'm really delighted.
Theme of the day.
Yes, I'm delighted to be here with all of you. I am chief of staff at Microsoft for our GC, but before that, I, for about 8 years, was an IP expert and led the trademark team at Microsoft, and developed a passion for this topic actually back in law school while studying the progression of a case we'll talk about, which is Native American activists work against the Washington football team's trademark. And so I identify as a Native Hawaiian and Indigenous person. And so thinking about racist branding just felt very personal to me from starting at that point in my legal career. So really excited to share the knowledge that I have to offer on this today.
And our third panelist today is William Thomashower, who is counsel for Pryor, Cashman, LLP.
Hi, so I think my mic is on, and I apologize that I got to wear a headset here because my my system gives feedback otherwise, so I don't look as pretty. But I'm a counsel at Pryor Cashman, which is a big New York City, Manhattan firm. We have a big IP department. I did IP for 30 years before I went to Pryor Cashman as counsel. And my real claim to fame is thanks to Professor Matima and IIPSJ for awarding me an award last year for 17 continuous years of speaking at the IIPSJ on various social justice and ethics issues in IP. So I'm really thankful to be back again, although it's remote. I like it better when we're in person and we can have our faculty dinner the night before. But thank you again for keeping me on the panel, and I think we'll have a great program for you.
All right, next slide, please. Next slide, please. There we go. Perfect. So why are we here today? So in 2020, police brutality and racial inequality once again came to the forefront of public discussion and political movements. Since then, as a society, we've been examining all the threads of discrimination that are woven into our culture and even our system of commerce. So while trademarks are source identifiers, these racist names and terms have also been preserved in the honey of nostalgia in order to sell things to everyone. And this is something that developed during the 19th and 20th century that has just snowballed everywhere, so that it's become so commonplace that Aunt Jemima is just a part of the culture and no one can immediately see a problem with it. But today we're going to talk about some of the impacts that the recent changes in legislation have had on different ecosystems for our different ecosystems in our world. So when we look at a mark like Aunt Jemima, we don't necessarily see the racial basis for it at this time. But if we actually dig through it, this image of a apron-wearing mammy who's always smiling actually came from a minstrel performance of Aunt Jemima that was drag and in blackface. So all of this together is trying to preserve the image of a subservient Black woman who is there to preserve the racial ideologies of white supremacy, where blackness and brownness represents subservience and also justifies discrimination. The mark Uncle Ben's also piggybacked off of this and developed later on. And then as we continued throughout the 20th century, Native American marks also started to pop up, and they were stereotyped as warriors, which helped to erase the fact that they were subject to assimilation and violence. So what we'll cover today, next slide, please, is the legal background and the treatment of scandalous, disparaging, and immoral marks, the impact that it has on different ecosystems, including the public, the USPTO, and corporations. Lost my mic there. So to take us through the history of scandalous marks, I'm going to turn it over to Bill. Oh, we're on mute.
Sorry, I had to unmute there. Thank you, Makalika. So this slide just gives you a little history here. And I haven't been around for all this, but I've been around for decades. So back in 1905, when I was not here, the first trademark law actually said you couldn't have scandalous marks. And then when Representative Lanham enacted the current Lanham Act, which has been with us since 1947, when it became effect, they added you can't register disparaging. That all was undone in 2017 in Mattel versus Tam, the Supreme Court ruling that the Slants, an Asian rock and roll band, which we'll see in a slide or two later, tried to register the Slants for their own band. Slants was a disparaging term for Asians, and yet they wanted to take that term back and take control of it in a positive manner. But, you know, your subjective intent is not what the trademark office looks at. So the examiner said, no, it's disparaging. You can't have it. But they won. So now they can have it registered. 2 years later, once the Supremes said that section of the Lanham Act was no good, it was not a far stretch to say that scandalous words in Iancu versus Brunetti could also be registered. And Brunetti had lost several appeals trying to register FUCT, which is spelled different, but sounds like the scandalous word that it is. And he was rejected. And then the Supreme said, nope, First Amendment lets you register that one too. Next slide, please. So there was case law prior to this that you know, you wonder why was the statute there in 1947 and nobody had this problem before? And the answer is because in these cases that are cited on the screen, McGinley and Holiday Inn, the courts had said there's no First Amendment problem. You can use those words, bad as they might be, as much as you want. That is our First Amendment. People allowed to walk on the street and say whatever they want, almost. Can't yell fire in a crowded theater. But you could, and you can't defame people. But, you know, these words could be used, and they could be used to sell product, but you can't register them. So that was deemed to be okay from a First Amendment standpoint. And that's what that slide up on the screen is telling you for all those years from 1905 to 2016. Next slide. Then we come to pro football versus Black Horse, where in this case, the Washington team wanted to register their terminology that they've used forever. And they spent a lot of money fighting it all through the courts. And the courts, the trademark office and the district court said, no, this is disparaging, can't have it. It was up to the Fourth Circuit. It was on its way to the Supremes, but it didn't get to the Supremes because before they could get there, the other two cases got there and basically said, yes, you can register this. So again, this is something that was actually good, and in my opinion, that we shouldn't register these words. You can use them. Supremes didn't see it that way. They don't listen to me, that's for sure. And they didn't listen to the prior precedents, which also said there's no First Amendment problem. It just can't register them. Next slide. So this was the first case in 2017, Mattel versus Tam, and that's the ban. A bunch of nice-looking Asian guys who want to just register the slants so that they could take control of it, and they were rejected until they got to the Supremes. And as it says at the bottom, the Supreme Court held that the prohibition on registration of disparaging marks like slants is unconstitutional under the First Amendment because it is not viewpoint neutral. It's somebody taking a view that it's disparaging. I could answer that, but they didn't want to hear me, so we have to take the law as it is now. That can be registered. Next slide, please. And this one, Iancu versus Brunetti, there he is, or somebody, I don't know if that's Mr. Brunetti, but wearing the shirt.
He's a model. He's just a model.
Oh, he's just a model. Okay, good. And he also was rejected. But then when he got to the federal circuit, by that time, they had already had the TAM case. So they said, oh, well, based on TAM, we have to let this go. And the PTO said, well, we don't agree with that. Scandalous is a little different than disparaging. So we'll take that to the Supremes. And the Supreme Court, in this case, said, nope, that scandalous is also okay. So that has to be permitted. The USPTO in response had to then change their guide, which is called the TMEP, Trademark Manual of Examining Procedure. And we didn't make a slide on it, but it is up here. It exists. You can look at the TMEP. And they removed the restrictions that had been in the TMEP because that had followed the statute that said examiners should reject trademark applications to register words that are scandalous or words that are disparaging, not, very importantly, not because the examiner thinks it's that way, but because there's a record that the examiner can find or that people can bring to the examiner or to the trademark office in an opposition or cancellation, as it was in the Washington football team case, that shows that a certain percentage of the people find it to be scandalous or find it to be disparaging. So it's based on evidence. It's not quite the way the Supremes think. It's just the government restricting your speech and your registration. What's our next slide? Let me see that one. So the effect of this is that all these disparaging marks can now be registered. These had previously been rejected under Section 2A. I'm not going to read them, but they're obviously, you can see the disparagement in these things. And you can think of more. So that has opened Pandora's box, and now there's an unlimited number of new disparaging trademark applications that are working their way through the system, and some have already been registered. Next slide, please. Again, these are examples of racist or otherwise disparaging terms being used. You heard a little comment about Aunt Jemima. I think that's a sort of an interesting case because I like the product, and we can get in deeper to have the change that they've now implemented. It's actually been implemented in some sequences which are creating some issues, but we can talk about that. But these are well-known brands, but they have inherent racist concepts. And certainly when you start looking at the history of them, you find out what you didn't know maybe as a kid, that there's some racism behind them. Maybe to some people it was obvious from day one, but I'm just saying that there is history that can be found that supports that racism.
And these are all the brands that are making voluntary changes.
Yes, thank you very much.
At this point.
I missed that. Yes, that is actually correct. Those are the brands that have decided to make the change. And we, should I say we can thank the upheaval of 2020 in having greater commitment to making changes to get rid of these racist concepts? Yes, but people had to lose their lives for that. That's not a good thing. So that's a positive outcome, at least. And of course, not all corporate America. These are the ones that have so far committed to change on this. The next slide has to do with the ethics of this, which I can do probably in another minute. Is somebody clocking my time there? How am I doing on the 10 minutes?
Yeah, finish up in this minute and we're good.
Good. Next slide. So something that I had looked at when the Mattel and the Brunetti case were floating around is, as a lawyer, do you want to represent somebody who wants to register a disparaging or scandalous mark, even though it's now legal? Is that something I have to do? And the ABA rule, which is followed, by the way, in many of the jurisdictions where our guests today and our participants are practicing, certainly Virginia, New York, not every state, but most states have followed the ABA model rules. And you'll notice that the lawyer under Rule 1.16, the lawyer does not have to take an action which the lawyer considers repugnant. It doesn't have to be illegal. It just has to be you consider it repugnant. So a client comes to me and wants to register a scandalous mark. The first thing I'm going to do is or a disparaging mark. The first thing I'm going to do is try to remonstrate with them and suggest that from a marketing standpoint, that's not your best choice of a mark. I'd like to register something for you. Let's be more creative. Think of something that'll actually sell the product better. But, people come to you with crazy ideas, and you don't have to represent them if you don't want. So these slides indicate that the lawyer has the right not to do that, to refuse to do that. They'll find some other lawyer, or they'll do it themselves, so it doesn't mean you're going to stop it, but just a point for the ethics of what our IP lawyers across the country should be thinking about. Let's just see what our next slide is here. May be it. Yep, that's it for me. So thank you. Back to the moderator.
All right, so next slide, please. So we've heard about the basis of we've heard about the changes to the law, and all of these changes affect different ecosystems in our world. So now we're going to kind of dissect that. And if you all have questions, feel free to put them in the chat, or if you need clarification about terms, we definitely want to be as clear as possible, so let us know. We will start with how this is going to affect the public. Next slide, please. Makalika, how does this change in the law affect the public? Like, since I was able to use a disparaging mark before these changes happened, does this change actually have effect on me as an individual?
Yeah, so I love the way you teed that up, Shelley, because really what you're saying is like, what did it do? What did it not do? Right? So what did it not do? Just to underscore and a little bit repeat what you said, it didn't all of a sudden make it possible to use these words commercially, right? The use was allowed before. And which is what has always made this sort of a funny First Amendment case, in the sense that, like, for, you know, most lay people, you'd probably say, like, your speech isn't being curbed, right? Because you are free to use these words for these purposes. But what it did is it now allows these kinds of words and images to be registered as federal trademarks and receive the benefit of trademark protection. And so then what's the implications of that? Well, first, what it might do is encourage adoption of these kinds of marks by parties that don't mind, maybe even enjoy, the offensive and discriminatory meaning that they have, right? So I totally agree with Bill's comment. You know, when you see things as a practitioner in this space, when you see these kinds of, you know, maybe not squarely legal issues, or maybe a blend of legal and not legal issues, you know, it is a best practice to help flag it. Now, usually most IP lawyers are not best positioned to be sort of, you know, a cultural analysis. So when a client has the means, you know, it's actually better to just direct them to try to get that kind of more cultural lens and analysis applied from an expert. But, you know, it is good that we at least issue spot for them. But the reality is, in as many cases as it's unintentional, it might actually be intentional. And so, you know, for folks who are entities that actually don't mind, maybe it's even their goal to be provocative in this way, you know, what this legal change does do is it might encourage them to go ahead and proceed with those terms and marks, because they can now protect them, which is like an added benefit to them getting the meaning of the mark. And so then what does it mean when something becomes a trademark asset? And some of this might sound like stating the obvious, but I'm actually not sure that people are fully appreciating what that means. It means you're going to create a market for these marks. Like, registered trademarks are assets that are bought, sold, and licensed, right? Like any other IP assets. It makes it possible then to have IP disputes over the use and registration of these marks. So, you know, that means you then get to leverage, you know, for whatever the modest filing fee it is to, like, get into the court system. You now get to leverage the justice system and its constrained resources to fight over who gets to use N-word kind of trademarks and things like that, which, you know, as a taxpayer, you might feel a certain kind of way about. You know, it's really given people the ability to bring the full force of America's IP system and justice systems to bear in monopolizing these marks as IP assets. So that's what it's done. And I think that
Does that mean that there's more pressure on us as individuals to actually advocate for the removal of these marks? Like, is there a benefit to doing that, especially for young children who might see these marks and also are absorbing all this information about, like, what these are actually, like, the racial ideologies that these are preserving?
Yeah, I mean, what you're saying is, like, what is the next level implication of this being out there? And, like, what I think another way to frame it is, like, what harm is this really causing? And then what's the make sense reaction to that harm, right? And so, I'll draw on the long multiple decades dispute over the what was styled the Black Horse case, which was multiple suits actually over the years to contest the use of the R-Skins racial slur by the football team in DC. So as a part of that long saga of activism and kind of fight, the Native Americans got all kinds of responses as to why they shouldn't be upset about the mark, and some of those were basically like, oh, well, it honors you, it doesn't really hurt you. And so it does raise that question, Shelley, like, is this really a big deal? Like, why does this matter? And so they were forced to kind of, they carried the burden of countering those arguments. They actually had to go out and invest a lot of time and energy and resources to sort of, satisfy scientific demand, or demand for scientific evidence behind what I, personally think is kind of common sense, which is that this stuff is hurtful. And so I just want to like maybe give some context. Like you teed on it a little bit when you were laying out the brands in your introduction, but just if you look at how Native American depictions are leveraged just in sports, in 2014, as a part of the work to study how this impacts Native Americans, a scrub of the Mascot DB website, which includes over 47,000 team nicknames in the United States, at least at that time it did, found that over 2,000 names were associated with Native Americans. 780 of them referenced some concept of warrior. Another close to 500 leveraged the term Indian. Other examples were raiders, braves, chiefs, chieftains, things like that. And a lot of the institutions using these kinds of brands were high schools, but all different kinds of sporting organizations used it. So about 8% of high schools were included in the list of U.S. high schools were included in the institutions that use these mascots. And so what that means is like, just imagine you attend one of these 8 in 100 high schools in America that leveraged a Native American depiction and name as a mascot, or that you go to a school that plays opposite one of those schools, right? So this actually was affecting large swaths of our youth and our communities. What are people going to be doing at those games with those brands? And actually, it's not hypothetical, because since so many teams use them and have used them, like I didn't make a slide about it because I don't love, spending a lot of time on the images because they're quite hurtful, but it's not hypothetical. You can easily find it, right? They're dressing up in fake headdresses and other regalia. They're painting their faces red. They're mocking indigenous identity, making war cry sounds. Being careless at best with the things that may be very sacred for some Native American groups, and undercutting Indians. Right now, the depiction of an Indian becomes a thing that you get to, heckle. You get to, undercut them when they lose. It creates an adversarial relationship when you're opposite those teams. And so for Native American youth that were absorbing all of this, and continue to actually, because not a lot of institutions are still using this kind of branding, they were able to study and show, hey, this contributes to depression. It undercuts their self-esteem. It increases acts of discrimination that they experience in school. It can increase the rate of self-harm and substance abuse. So these were things just found around studies on mascots for youth. But I think that, again, like calling on our common sense, you can easily imagine how these same findings you would expect to find if it's, N-words and other racial slurs that kids are finding a lot of others wearing in their communities. They go to the mall and that kind of thing is just, no one's batting an eye to see that on shelves. So, I think the harm is actually really, really serious. The implications of this change in the law, the Supreme Court has very thoroughly analyzed this in its decision. And so, the law is what it is, but I think now we have to decide like how we deal with it. And I think helping people to understand, like, actually the implications are very serious. And then I would say it also, what this determined is that the fight on these brands has never been restricted to just trademark battles under the Lanham Act. It was never only that strategy. But it did take that part of the strategy out of the toolbox, right? And so as you look at like the different forms of activism and non-legal power that has been leveraged, I will just say like Where we're seeing gains, great, but it does put minority groups at a severe disadvantage when you're basically having to fall back to winning over the court of public opinion. Native Americans make up less than 3% of the US population. So when the fight against this kind of branding falls on them, that's just very, very difficult. And it was difficult for decades with the DC team's name. So yeah, I think the harm is pretty substantial.
Could you just quickly, Makalika, explain how the use of disparaging marks has an international effect?
Yeah, well, I guess what I would say, and this probably kind of starts to lead into what I know LaNelle is going to cover on how corporations will need to think about this. These decisions were made very much under the First Amendment jurisprudence. Our other countries are not going to be doing that kind of analysis, right? So it will look different, and you can expect differences in where other countries will land. And the sensibilities of other markets might not align to the U.S. market. And so one of the things that people should know as they're counseling clients or thinking about this issue is, corporations do need to be careful about assuming that they can use something here and protect it as an asset and that they'll be able to do it abroad. It's just going to be uneven, and it's analysis that will have to be done like country by country.
Thank you. So next, we will hear from LaNelle Owens about corporations. So LaNelle, as brands abandon their disparaging marks, what impact is this having on in-house counsel? Like, what are your challenges, and what are the considerations, and who are the stakeholders?
Yeah, so this kind of rebranding, sometimes it happens a lot. You'd be surprised. And oftentimes, IP counsel is not told that they have changed and they've pivoted to use a different logo. And so it adds additional salt into the wound when the corporation makes a public announcement that they are going to abandon, especially like their main brand. And I am sure Trademark Counsel was probably in the process of negotiating with third parties enforcing against that mark when this announcement came out in the summer. But it's something that is a pain in the neck, but it's also something that can really and get you really excited, and you start to think outside of the box on what do we need to do to kind of maintain this asset, because we have to be honest, especially like with the Aunt Jemima brand, Uncle Ben's, and all these others. These are $1 million, billion-dollar assets. These are intangible assets, and the company is not throwing that away. Like, do not be fooled. Like, there is a way that they're trying to figure out how do we maintain our asset, even though we're moving away from the actual image and the word and the term. And so it's something that I'm not surprised. If you look at the website, they talk about, at least for Aunt Jemima, that they're transitioning to, I think it's paper milling company, but it's a slow progression, right? That absolutely makes sense to me, because you're trying to figure out, what do I need to do? How do I figure out what we're going to file, how we're going to enforce, how do we stop all these bad actors? And there's all these kind of spiraling things that happen that they're now having to grapple with. And I know Bill will talk about it, but like within days of them announcing, there are 3 to 4 different people who then filed Aunt Jemima trademark applications for pancakes and waffle and syrup and that kind of stuff. And so it's like, okay, what do we do? There's always been this pronouncement that we're going to abandon. And so at least I would not, I would think twice about opposing. I would maybe let the trademark office do the work, right? Aunt Jemima, some of these other brands, you already are on the register. And let me back up for the students. The principal register is where you register your trademarks with the U.S. Patent and Trademark Office. Let that be the prima facie case for the examiner to kind of knock these other applications. Because there are multiple applications, they're going to have to fight themselves out as far as who is going to get to the front, as far as now you're going to have to figure out how do you get over these Aunt Jemima registrations. So it's a good thing that they have things on the registry, and people are going to have to wait essentially until they expire. So from a strategy perspective, you have to think about what else do we need to file to kind of keep us on that register, because eventually people are going to start filing cancellations, and you're going to have to deal with that. But if you're very smart and you think outside of the box and how different types of goods and services that you can possibly offer to file to kind of maintain some of those rights. So maybe it's museums and exhibitions, and there's this kind of talk about this vestigial use. Because companies that are 100 years old, and I've had experience with that when I used to be in-house counsel for John Deere, like they usually have a historian. They usually have like a museum or someone who has tracked the actual company and the brands. And so if you're able to use the mark in that way, that helps you to kind of lengthen how long you're going to have your rights. The other thing is maintaining the trade dress. So if you looked on your phone and if you type in pancake syrup and then hit image, within Google, you will see all of these different like images. And I have like this here, right? So if you look on their website, that paper milling, it looks exactly the same. They just changed the words because the trade dress is powerful, especially in consumer packaged goods, and sometimes you'll hear CPG. This is why children know what is their favorite cereal before they know how to read, because they go down the aisle and they look for whatever, Captain Crunch. They look for that image or they look for the color. And so if you look, Aunt Jemima really has had like this red kind of look. They have this medallion up top on their syrup. So these are the things that they're really going to push because you have to, especially from an international perspective, because there are bad actors out there. And what you don't want to do, and this is kind of these trickle down kind of things for a food item, now you run up against compliance food safety issues. And so if someone's out there with this knockoff brand that looks very similar and someone purchases it and then they get sick or whatever, that actually goes back to the main brand because they said, oh, I thought I was, purchasing Aunt Jemima or Uncle Ben's or what have you. And so those are some of the headaches that in-house counsel has to kind of think about, like, what do we do? How do we handle this? Even though we know we're moving away from this particular asset. I think what is good for brand owners and some of these other kind of famous, for lack of a better term, iconic brands is the Lanham Act does have 1125A, where someone can't file something for a false origin, false sponsorship. You can file for unfair competition because trademark rights, they rest in it's a source identifier. And so if someone doesn't have a really good bona fide reason why you need to have the monopoly on Aunt Jemima, you can't have that. And so I think that helps them because they have the famous mark. And probably the first conversation that the IP department has to have with corporate is we need an increase in our enforcement budget because people are coming out of the woodworks. There's, these new applications, they're undermining maybe some ongoing settlement agreements, some coexistence agreements that you're having in the domain space. Now they're going to have all of these other Aunt Jemima websites that are popping out. And so it's this constant thing, do you have to spend more money to have a watch service, to watch who's, filing? Do we have to then also watch domains and what are the activities that are happening? And then you decide, how are we going to respond to this? And then I also would want to push IP counsel to think outside of the box, where this is an actual awesome time for the team to start thinking about innovative ways. So, if you're going to get rid of the Aunt Jemima or whatever the trademark is, you still have other tools in the IP suitcase, right? So if the packaging designers, if they can come up with an innovative packaging or product that then maybe you can apply some design patents around to kind of lengthen, again, get your monopoly to kind of continue to kind of fight against these third parties. And then I just would be remiss if I didn't think about, or at least offer from a social justice perspective, how corporations maybe want to consider how do they continue to make money off of these disparaging marks without continuing to harm the communities that they're directed towards, and maybe from a licensing model. Like, it would be wonderful if some of these corporations maybe allowed some of the museums. I can think of the DuSable Museum, because Aunt Jemima was based off of a woman from Chicago, so was Uncle Ben, or the Smithsonian Museum, the Schomburg Museum, many of the other Native American museums and Latino things that could allow them to do these exhibits, and that they could actually use these images in a licensing structure, so that the rights, of course, still inure to the benefit of the owner, but it kind of keeps them alive. And then maybe even to HBCUs, because they are good foundation for critical race theory discussions. And so I think there is a way to think outside of the box, on how you can kind of protect this asset, because they do not want to throw away that money, that intangible asset. They don't. But you have to think really smart about how you come up with something that allows you to keep the asset, but without also harming the public.
Thank you, LaNelle. So do you think that there's a social responsibility as an attorney of color to have to play a certain role in these changes, like in the corporations? Like, how big of a voice do you have to have?
So my flippant response is absolutely not, because we're tired. Attorneys of color have probably been doing this for a very long time. Even, I know we're talking a lot about Aunt Jemima just because it's the most current case, but I'm sure there was a Black lawyer, a Black marketing person, someone, when they changed Aunt Jemima to have a perm, someone probably said, this is not a good idea. Can we just change different, image? So I really think that the responsibility is also on non-people of color to really understand, this is what these images do, and kind of going back to the international context. Much of the American media is consumed in other countries, and that is how they develop their ideology about certain races. And so in consumer packaged goods, American products are considered high quality, they're most desired. And so if they are selling Aunt Jemima, Uncle Ben, cream of wheat, and some of these other products, that is their image. And they've never seen a Black person. That is the image that they have of that community. And so that is a harm, because when you are Black or you're Native American, and then you go to these countries and you get this reaction from the people, in some way it's not their fault, because that is what they have consumed from our American products. So yeah, that is kind of my take on it. I think you have to have a voice, but don't always feel like you have to have the whole world on your shoulders, because we're tired. I know I am. And so I think it is on the bar as a whole to push towards more justice in some of these marks.
I think you're so right, because we know what the problem is. We need the allies to do the work as well. And so moving on to our next ecosystem, Bill, will you tell us some of the implication issues that this has for the USPTO, including, you can tie in some of the Aunt Jemima that we've been talking about, and we can, will you show the next slide, please, Lynette? And take it away, Bill.
Thank you. So I agree with everything LaNelle says, by the way. And you don't have to be a genius to figure out that the corporations need to look to their stakeholders. And who are the stakeholders? Well, the stakeholders are their customers, obviously up front, their employees, how do they feel? They're shareholders who don't want to lose value but want the product to continue to go and be successful. And there's the advertising side, which is probably the most impactful. My understanding is that the Washington R-Skins team actually moved after winning the right, but through the Mattel case, winning the right to actually register that and spending all that money, they went the other way. Why? Because the advertising people said, we're not going to advertise in your NFL game if you have that name. That's multi-millions of dollars. That's impactful. So coming to this slide here, what I did here was I just brought up yesterday. I'd seen it before. If you search Aunt Jemima, it's a nice product. I like the pancakes. You search the product and you search the brand, and this is what it brings up. So I then annotated that, which is hard to see on this slide, but the top three really, the first three are actually pirates, people coming in, have nothing to do with Quaker Oats or the parent company PepsiCo, and they are filing for Aunt Jemima. At least they kept it in the food class, as opposed to they could have been more vicious and filed for Aunt Jemima with a scandalous purpose and using it for a different product altogether, something that would be really tarnishing. But they kept it in food, and the first application there is an individual. I can call him out. It's public record, Eric Carrick. The second one is U.S. Brand Equities, and the third one is Retro Brands. And all three of them, as LaNelle points out, they get rejected by the Trademark Office doing their job, but they get rejected for the reason that Quaker Oats still has its registrations for Aunt Jemima still valid and existing. Now, eventually, those registrations will go away, potentially for non-use, unless there is a way, a clever way, as LaNelle points out, for the company to keep that brand alive, at least for purposes of keeping the registration alive, which is going to be tricky because you have to show use for the product, and they're not selling the pancakes with it anymore. So that's an interesting point. If you look down on this slide, you'll see in the middle it says footnote, because I didn't have room to put it, and a footnote at the bottom in small print. You can't read it, so I'll read it to you. The footnote for this particular Quaker Oats registration made the point. It's an old one. This is a quote. Aunt Jemima is a fanciful name and does not refer to any known living individual. The portrait also does not depict a living individual. Now, that's not a clever phrase by Quaker Oats. That's actually in the TMEP. You cannot use a name or portrait of a living individual unless you have their permission. It's a little cute to say it's not a living individual because they didn't have to say where it came from, which could have had I think there's evidence it had a racist background. So they didn't have to get into that. That being said, again, you have the problem of these pirates coming in, and for now, the PTO is doing its job, and I think LaNelle's point is really good. It's going to have to be a clever way, whether it's a museum, whether it's a vestigial use of some kind, or 1125A, an unregistered use that could still stop these people from coming along. And it's not just Aunt Jemima, it's going to be everybody in the category. The rollout has been a problem for the corporations. How do you change? You need to go to all your stakeholders and you need to do focus groups and figure out what's going to be acceptable. What they came up with was Pearl, P-E-A-R-L, Pearl Milling. I have the illustration of it here. This is from their website. That's not a slide, but Pearl Milling was actually the name of the company that had started out in inventing this flour. And at first I was concerned, and I'm not their trademark lawyer, but I would have jumped on them and said, well, wait a minute, where'd you get this pearl? Is that also a racist background? And it turns out pearl is actually a technique for milling flour. So it's a legitimate reason to go to pearl milling. And so they went to that, which is reasonable. However, if you check on Twitter, there has been backlash to that. There are people who find Pearl Miller to be maintaining some of the same racist imagery. So you're not going to please all the people all the time, but that's what they did. Even on this Pearl Miller rollout, I was concerned to see that the image of Aunt Jemima was still showing somewhere on the bottom front, although it turns out that they say they want to put it on the back of the package. So the packaging is rolling out. Last week I went shopping. I can do what LaNelle did. I got the paint. She's got the syrup. I got the actual package. The new package doesn't have the image. We don't see the black lady with her kerchief, okay? They hadn't moved to Pearl Milling yet either. So they kept the Aunt Jemima, but they took the image off. So that's a step in the right direction. But now this product was probably manufactured about 6 months to a year ago based on the expiration date, but we're going to be seeing the pearl milling come rolling out pretty soon. And so that is the challenge. And we're spending all this time just on one brand. Imagine what you have with all the others we saw, Uncle Ben's, Land O'Lakes, Eskimo Pie. All these brands have this issue as to how they're going to change, but at the same time protect the brand from falling into the hands of pirates who will put out a less quality product or even worse yet. So I think that's the challenge in enforcement and in the PTO. And I think LaNelle is right on that the companies are going to have to be very aggressive in knocking down pirates and finding a creative way, whether it's design patent, vestigial use, trade dress, to stop these people from turning these brands back, just bringing the brand back for the very reason that it was taken, that the company wanted it taken away. So it is a bit of a catch-22. You don't want to use it, but you want to keep the right to keep others from using it. That's a catch-22, unless you can be creative. Thank you.
All right. Can we go back a slide, please? Did you have any other comments on the PTO bill?
Well, just the point that I mentioned before, that the PTO, as a result of the lawsuits, had to remove, and it's on the slide, TMEP 1203.03 has a couple of different subsections, but the ones that dealt with disparaging and immoral had to be removed, and examiners were told they can no longer reject on those grounds. So in these pirate cases, for example, they're not rejecting because Aunt Jemima is disparaging. They're rejecting because Aunt Jemima is already registered to Quaker Oats, and that's just a direct conflict for the same product. But as I sometimes tell clients, you can almost get the same trademark if it's not too famous, if there's a huge difference in the product. So hamburgers and helicopters are very different, and you could have, Sikorsky hamburger and it wouldn't conflict with Sikorsky helicopter. Maybe you could have McDonald's helicopter, it wouldn't conflict with McDonald's hamburger. So those are ways around potentially, but it is a concern, and you're going to see these problems roll out as more pirates come in. And the pirates are there because they as soon as the Supremes, these people think, well, let me be first in line. Even if I get rejected, my application will be first, and someday I may get it and be able to sell it. So that's going to be a problem.
Yes, they were fighting for that priority date, all right.
Exactly.
That is a flood. That's a flood of applications. So we do have a question for Makalika. How can employees and these big companies encourage their allies to assist, to effectuate change?
I think that's a great question, and I'm happy to answer it, and then I'd love to hear what LaNelle thinks too, because she's had multiple in-house experiences, including the one she has right now. So, a lot now, basically the law is such that, these can be lucrative trademark assets as well as branding assets and marketing assets. But of course you can choose other things, right? And so I think, trying to help bring your company to enlightenment as to, what is offensive about marks if you see it. Trying to tie that to work your company's doing around driving diversity and inclusion and equity. It's always helpful if you can come at it, when you're internal, you want to come at it in the spirit of helping the company be better, right? Helping the company show up better to the customers that you're trying to reach. And it never hurts to just be a little vulnerable about what it really means. I mean, a lot of times when I talk about this, actually, I feel I feel like I show up as kind of an odd IP expert, because I actually find that, it's the IP arguments and the First Amendment arguments are really important for courts because that's what they need. But when I'm talking about it, I just try to actually use really accessible language. Like, this is hurtful. It hurts me. This actually is hurtful to my family. It's hurtful to the community I come from. So I also would just say, hey, IP professionals, it can be a very cerebral area of work, as all areas of the law. And I feel like it's actually most effective to just be very human about it. I think this is a very human thing. So that's my thoughts.
Can we go to the next slide, please? And LaNelle, what were your thoughts on that?
Yeah, I think it goes back to how you train your clients to do the right thing. And whether it's something that is disparaging and hurtful to just something that is completely opposite of the company image, you can speak up about it and make sure that your client is aware. I think the success is when you train your clients so well that they then believe that they brought up the idea that maybe we shouldn't do this. And that takes a while to establish like that trust with those clients. And it is hard because in-house counsel is overhead. And when you are debating something, they don't like it when we have to tell them you may have to pivot in a different way, even when it's not like a disparaging mark. And when it's a buyer who has this huge category and this is a top product in the brand, top shelf, and they have $1 million SKU, like that's already a tense conversation, right? And so I think it's about how you work with your clients and establish those relationships so that they begin to trust you. So that when LaNelle says, "Oh, I don't think you may want to, do that," they like, "Oh, if she said it like that, then maybe we should take a step back and think about it." But yeah, that's the way that I've kind of done it, just in general, to just kind of call it out. Like, "Are you sure you want to do that?"
So we have another question, and I'll open this up to the group. So we referred to the attorney's obligation in these cases, but what is the duty of marketing and brand experts? Should they be a part of the conversation? Do they have a responsibility to this as well?
Yeah, this is Bill. I would say they actually have a corporate responsibility. They're there to assist marketing to sell the product. And if they're alienating a significant portion of their customer base by using something, marketing speaks up and says, "That's not a good idea." And here's why. Not because I don't like it necessarily, but because a significant portion of your customer base is not going to like it. Or even if it's not the same, it's not a customer base issue in terms of race, it could be a customer base issue that people are offended that you are doing this, regardless of their race or viewpoint of it. So you need to really appeal to a broader base than you're thinking about. Now, that's not an ethical obligation. It's just part of your role as corporate marketer, I think, to say that and to come up with that. As LaNelle points out, in-house counsel, and I'll tell you, out-house counsel also is overhead. And a lot of times, the corporate doesn't want to come to counsel because, as a famous lawyer once said, a lawyer is professionally trained to find 3 problems with every solution. But I tell clients that's correct, and you want that because I'll find the problem before you get sued for it. So that's exactly why you should come to counsel. Let's figure it out before you roll out. LaNelle, did you have a thought about that too?
I mean, I agree with what you said. I think it's a broader conversation about when we're talking about who's at the table, and having more people who can speak up and recognize when something is an issue. Growing up, I did not know that Eskimo pie was offensive, right? But if I can see if I was in a corporation and if there was someone of that background for them to say, "Oh yeah, that does make sense." Like, I know what's offensive to me as a Black woman, but I cannot and I will not say or assume that something else is offensive. And so I think when you have to have other people in the room, diversity in the room, so that people can speak up and have their say, and also not tell a person of color or whatever marginalized group how they should feel about a particular image or word.
Yeah, one of the things that if I could add to what LaNelle just said, and something she said earlier about like companies of size typically have archivists and historians. Another thing that I think companies of size have that I wish was more accessible for branding organizations of any size is the access to expertise to even get awareness and analysis on these issues. So a lot of practitioners in the trademark space will do their best to help provide that, but it really is a different thing than legal analysis to figure out the pure trademark risk. And so, you know, I've been fortunate to work for a company that has access to an incredible team that is able to help do that and think about it at a multinational level. And, you know, as I kind of think about like call to the profession and sort of the industry around marketing, I mean, thinking about how to grow that muscle, grow the access to that service so that people can do this when they mean to, I would love to see that happen, you know, and talk about how do we get more companies that, because, you know, it isn't practical to have it for, you know, less than large companies, right? Because to the point about the overhead.
So just to play devil's advocate here a little bit, what if we work for Brunetti? Like, what in that situation, if that is your client, and you are in-house counsel, let's assume you're in-house counsel for Brunetti and the brand is fucked, like, and you know the connotation of it, what are you going to do? Like, are you going to feel obligated to say something to your client about this and then bow out if they do not want to change this in some way, or if you do not agree with this? Because a brand like that, they know they're going to offend some people and they're cool with it. So what's the conversation there, and what are the different challenges that you're going to face, and how would you react to them?
Well, I can tell you, I actually had that spelled differently, that somebody wanted to register, and I tried to explain from a marketing standpoint why it would not be good. But as you say, sometimes somebody wants to register it because it's edgy. It's going to upset people. And I think that was Brunetti's argument. He was doing that. And then he would get a customer base that wanted to be that edgy. You know, I don't want to go I can start talking about different customer bases, and your mind can wander to Washington, D.C. as to what you're going to see as to who would like to be edgy. But it doesn't mean that I, as a trademark lawyer, need to take that client. Now, the problem is there'll be somebody who will do it. But the point is, individually, we should be trying to hold ourselves certainly to a higher standard of social justice across the board. And the one way you can do that is you try to explain to these people why it's not a good marketing strategy. But if they want to be edgy, they want to do it, they'll find somebody to do it. But you don't have to be the one.
I think from an in-house perspective, if I'm looking at it solely from IP, I'm clearing to see if the mark is available for use and registration and that kind of stuff. And then I would also pull in public affairs and marketing. So all the stakeholders are in the same room so that public affairs would know how they need to respond, because, hey, this may blow up and it shows up in the New York Times. You need to be aware of this, because sometimes that helps to maybe change the decision, or so that the company is prepared. If they're going to be edgy, they don't care. And so that's one of those things, you know, where I always say, yeah, you can do it legally, you can do it, but should you do it? And they will decide from there. But I think that's when you try to pull in those different allies from different units in the business to have those conversations. Because depending on how big the company is, your shareholders may not like it.
That's very true. And who is going to perceive this comment and feel that it applies to them? Because is it sexually disparaging? Is it, you know, disparaging on a gender basis? Where, like, and that's the perception of this word, right? Like the fact that it can attack so many people and it's considered violent as well. So did we have any more questions coming in? I think that we're nearing the end of our time, if I'm correct. Lynette, do we have, how much more time do we have, Lynette? Oh,
we are actually at time. We were extended 5 more minutes because we started a little late, so.
Perfect. Well, thank you all so much. This has been such a great conversation. Thank you for the questions, and thank you to all of the panelists. for your participation. I've had a blast. Uh, and I guess we'll turn it back over to the coordinators.